Can a grandchild contest a will? Have you ever wondered if a grandchild can challenge a will? This question is important for many families, especially when it comes to inheritance rights. Let's break down how this works. First, a grandchild can contest a will, but it depends on several factors. One key aspect is legal standing. Generally, only those who have a legal right to inherit can contest a will. This means that a grandchild usually does not have direct standing unless certain conditions apply. For instance, if the grandchild's parent, who is the child of the deceased, has passed away, the grandchild may have the right to contest the will. This is because they can claim what their parent would have inherited. This is often referred to as inheritance by right of representation. Next, let's talk about the grounds for contesting a will. Even if a grandchild has standing, they need valid reasons to challenge the will. Some acceptable reasons include undue influence, where the person who made the will was pressured into changing it. Another reason could be a lack of testamentary capacity, meaning the person did not have the mental ability to understand the will when it was created. Fraud or forgery is also a valid ground. If the will was created or altered through deception, that can be contested. Improper execution is another reason. If the will was not signed or witnessed according to legal requirements, it may not be valid. Lastly, if there was a mistake or if the person intended to revoke the will, that could also be grounds for contesting it. It is important to note that a grandchild cannot simply contest a will because they think the distribution is unfair or feel entitled to more. They must present evidence of one of these legal issues. Inheritance laws can vary significantly from state to state. Some states allow grandchildren to inherit if their parent has died, while others have stricter rules about who can contest a will. This means it is essential to understand the specific laws in the state where the will is being probated. If a grandchild is considering contesting a will, there are practical steps to take. Consulting with an experienced probate or elder law attorney is vital. They can help evaluate legal standing and the strength of the claim. Gathering evidence is also crucial. This might include medical records or witness statements that support the grounds for contesting the will. Lastly, it is important to consider the emotional and financial impact of contesting a will on family relationships. Legal battles can be costly and may strain family ties. In summary, a grandchild can contest a will if their parent has passed away or if there are legal defects in the will. Without these circumstances, grandchildren generally do not have the right to challenge a will based solely on dissatisfaction with the inheritance. Consulting legal counsel is essential to navigate these complex issues effectively.